We've got a fascinating and, frankly, pretty complex topic for our deep dive today.
Mhm.
A listener asked us to really unpack the process of legally getting a firearm for personal safety in India.
Right. It's something a lot of people wonder about, but the details can be, well, daunting.
Exactly. So we've gathered our sources, the Arms Act, the 2016 rules, bits of the Penal Code, too, to try and make sense of it all.
Our goal is really to demystify it for you, highlight the key things a potential owner absolutely needs to grasp.
And the first thing that jumps out, based on the law, is that owning a gun in India isn't seen as a fundamental right, is it?
Not at all.
Huh.
It's very clearly positioned as a regulated privilege. This thinking goes way back.
Tell British Raj.
Yeah, primarily. Laws aimed at control, keeping arms out of public hands. And that focus on state control, it definitely continued post-independence. The legislation reflects that.
Okay, so to even start wading through this, we need some basic definitions. Section 2 of the Arms Act. Let's talk about arms. It sounds like it means more than just guns.
Oh, much more. The definition is surprisingly wide. Yes, it includes firearms, obviously.
Well, what else?
Things like sharp-edged weapons over a certain size, think swords, for example. Anything designed as a deadly weapon, really. Even parts of weapons and the machinery to make them.
Huh, interesting.
But it does exclude basic domestic or farm tools, like a simple staff or toys, provided they can't be easily converted.
So a really broad net. Then within arms, we get firearms. What's the specific legal definition there?
A firearm is specifically something designed to shoot a projectile using an explosive or, well, some other form of energy.
Okay.
So that covers everything from, say, artillery pieces and grenades down to things like riot pistols, devices that shoot noxious gas or liquid, even silencers.
Silencers too, wow.
Yep. And firearm parts, manufacturing gear, even the carriages for artillery. The key is that projectile propulsion.
Got it. If it shoots something using force, it's likely a firearm under the Act. Now, ammunition, I think bullets, but I suspect it's broader.
Way broader. Ammunition is basically anything used with a firearm. Standard bullets, sure.
Also.
Rockets, bombs, grenades, shells, missiles. Even stuff for torpedoes or mines.
Seriously?
Yep. And explosive or fissionable materials, noxious stuff, whether used in a gun or not. Plus fuses, primers, even specific ingredients if the government lists them. Very comprehensive.
It really shows the intent to control every aspect. Now, these terms pop up a lot. Prohibited arms,
Yeah.
prohibited ammunition. What falls under those categories?
Okay, prohibited arms. These are the most heavily restricted. Think automatic firearms.
Machine guns, basically.
Right, the ones that fire continuously while the trigger's held. Also, weapons designed to shoot noxious liquids or gas. Heavy stuff like artillery, anti-aircraft, anti-tank weapons.
Makes sense.
And anything else the central government specifically designates. It's worth noting that semi-automatics often get treated with similar strictness in practice.
Okay. And prohibited ammunition, does that just follow suit?
Pretty much. Ammo containing noxious stuff, rockets, bombs, grenades, shells, missiles, torpedo components, and again, anything else the central government specifically prohibits.
So the big picture is tight regulation.
Mm-hmm.
Which brings us neatly to Section 3 of the Act, the license requirement. Sounds fundamental.
It absolutely is. It's the cornerstone. Section 3 is crystal clear. You cannot acquire, possess, or carry any firearm or ammunition without a valid license issued under the Act and its rules. Period.
No loopholes for just having one around the house.
None. You need that license.
And I read there's a limit on how many firearms one person can even have a license for. What's the rule now?
That's right. It changed in 2019 with an amendment. The general limit now is a maximum of 2 firearms per licensee.
Down from
3 previously. Now, there are exceptions for licensed dealers, obviously, and for members of rifle clubs using specific guns like .22s or air rifles, just for target practice.
What about inherited guns?
Yes, heirloom firearms can sometimes be an exception too under specific license conditions. But that reduction really signals a move towards fewer firearms in private hands, wouldn't you say?
It certainly seems like it. So what happened if someone legally owned, say, 3 guns before that 2019 change?
They were given a year to deposit the excess firearm, the third one, basically.
Deposit where?
With the local police or a licensed dealer. If they were armed forces personnel, they could deposit it in their unit's armory. And then those deposited guns were supposed to be delicensed within 90 days after that year was up.
A big administrative task, I imagine. Okay, what if you don't have a license, but maybe a friend or family member asks you to take their gun to a repair shop? Is that allowed?
Section 3 actually covers that specific scenario. An unlicensed person can carry a firearm or ammo, but only if they're in the direct presence of the license holder, or if they have written authorization from them.
And only for specific reasons.
Exactly. Strictly limited to taking it for repair, for license renewal, or for the owner's own use. It absolutely does not allow the unlicensed person to just carry it around or use it themselves.
That's a really important distinction.
Mm.
Okay, let's tackle these terms. Non-prohibited bore, NPB, and prohibited bore, PB. Our sources say these aren't actually defined in the Act itself. How does that work?
That's a key point, actually. NPB and PB aren't formal legal definitions in the text. They're more like operational classifications that have developed over time.
Developed from what, then?
They basically derive from the definition of prohibited arms that we just discussed and how the power to grant licenses is divided up. It's about which guns are considered prohibited by law and which level of government can issue a license for them.
Okay, so generally, prohibited bore or PB firearms are the ones that fit the definition of prohibited arms.
Exactly. That category includes the automatics, continuous fire weapons, sometimes semi-automatics in practice, the noxious substance dischargers, and also specific calibers often linked to military or police use. Things like 9mm pistols, .303 rifles, 7.62mm calibers, .455 handguns. Also, smoothbore guns with barrels under 20 inches.
And the crucial part for PB is who licenses them.
Yes. Licenses for PB weapons can only be granted by the central government, specifically the Ministry of Home Affairs, or MHA.
Okay, so conversely, non-prohibited bore, NPB, what are we talking about there?
NPB firearms are basically everything else, the ones not classified as prohibited arms. These are typically your manually operated firearms.
Example.
Double-barreled shotguns, your classic 12-bore or DBBL, bolt-action rifles like a .315 or a .3006, revolvers in common calibers like .32 S&W long, .22 LR, .3 SRO, even some specific semi-automatic pistols in calibers like .32 ACP or .22 LR can fall under NPB.
And who issues licenses for these NPB firearms?
Generally, the licensing power for NPB guns rests with the district magistrate, the DM, or, if you're in a major city, the commissioner of police. They act under powers delegated by the state government.
So for the average civilian listening, if they're thinking about a firearm for self-defense, they're almost certainly looking at the NPB category, right?
Almost exclusively, yes. That's the realistic path for civilian ownership for personal safety.
Is it even possible for a regular citizen to get a license for a prohibited bore weapon?
It's exceptionally difficult, extremely rare. You'd need to prove truly extraordinary circumstances, like facing a grave, imminent threat to your life, especially if you live in a terrorism-affected area. Or maybe you fall into a very specific high-risk group, certain government officials, MPs, MLAs known to be under serious threat.
So not just feeling unsafe.
No, far beyond that. It requires rock-solid justification, incredibly thorough police checks, recommendations from the DM and the state government, and then direct approval from the MHA in Delhi.
Wow.
There's maybe a tiny possibility for very old family heirlooms under strict conditions, but generally, PB licenses for civilians are almost unheard of. The process is way, way harder than for NPB.
That really highlights the control over more powerful weapons. Now, besides the PB and PB distinction, the Arms Act has other key prohibitions, doesn't it?
Oh, definitely. Section 7, for instance, puts a strict ban on doing anything with prohibited arms or ammo, acquiring, possessing, carrying, using, making, selling, unless you have specific central government authorization.
Okay. What else?
Section 8 deals with unmarked firearms. It's illegal to tamper with identification marks, like serial numbers, or sell a gun that's unmarked. And if you're caught with an unmarked gun, the law basically assumes you tampered with it.
That seems aimed squarely at illegal trafficking.
Precisely.
What about who can legally own a gun? Are there age limits or disqualifying factors?
Yes, Section 9 is very clear. You cannot acquire, possess, or carry firearms or ammo if you're under 21.
Any exceptions for younger people?
We'll get to sports shooters later, but generally the age is 21. Also, you're barred if you've been convicted of a violent crime or an offense involving moral turpitude.
Moral turpitude. What does that mean practically?
It generally refers to conducts considered, base, vile, or depraved. Think serious dishonesty, offenses against society's morals. The ban lasts for 5 years after you finish your sentence.
Okay. Anyone else prohibited?
Yes. If you're currently under a legal bond to keep the peace or be of good behavior, you can't possess a firearm during that time. And it's illegal to sell or give a firearm to anyone in these prohibited groups or to someone deemed mentally unsound.
So the law tries to keep guns away from certain individuals What about the act of legally making or selling guns?
That's covered by Section 5. You absolutely need a license to manufacture, sell, transfer, convert, repair, test, or prove any prescribed firearm, other arms, or ammunition. You can't just set up shop.
Right. And I remember reading about limits on how much ammo someone can legally buy or keep.
Correct. Rule 23 of the 2016 rules sets those limits for individual licensees, like shotgun or rifle owners. You can generally buy a maximum of 200 rounds per licensed firearm per calendar year.
And how much can you possess at any one time?
The possession limit is usually 100 rounds per licensed firearm, unless you get special permission from the government for more.
That seems quite controlled. Now, this was interesting. Even air weapons are more regulated now.
Yes, that was a big change in the 2016 rules. Now, you need a license to manufacture, test, sell, or transfer any type of air weapon, air rifles, air guns, even paintball markers.
Any type.
Any type for those activities. And specifically, if an air weapon is more powerful, meaning over 20 joules of muzzle energy or a bore bigger than 0.177 inches, it can only be sold or transferred to someone who already holds a valid arms license, and it has to go through a licensed dealer.
What about less powerful air guns, like the common .177 caliber ones?
Even for those below the thresholds, licensed dealers have to check the buyer's ID and proof of residence and issue an invoice. Interestingly, you don't need a license just to own one of those low-powered .177 air guns yourself.
Yeah.
But, and this is important, if you use even a low-powered air gun harmfully, you can still face penalties, much like misusing a regular firearm. And sports shooters using air guns need permits from their clubs.
So the net has definitely widened. Okay, let's assume someone listening isn't disqualified by age or criminal record.
Right.
What are the actual eligibility criteria they need to meet to even apply?
All right, the basics. First, you have to be an Indian citizen.
What about OCIs? Overseas citizens of India.
There's a very narrow provision, mainly for inheriting family heirlooms, and they need to prove permanent residency in India and agree to deposit the weapon if they leave. So primarily Indian citizens.
Okay. Age.
Minimum 21, as we said, though there are potential exceptions for documented young sports shooters.
Oh.
You need to be mentally sound and physically fit. This requires a medical certificate, Form S3, from an MBBS doctor.
And a criminal record check.
Crucial. No convictions for violence or moral turpitude within 5 years of finishing your sentence. Not currently under a peace bond. The police verification will dig deep into this.
So ticking those boxes is just step one. Then comes the justification, right? Especially this idea of threat perception for self-defense. That sounds like the hard part.
It often is. It's absolutely critical. Just saying, I want it for protection, usually isn't enough.
What does the law say?
Rule 12 of the 2016 rules mentions needing a genuine requirement to protect life and or property based on your job, business, or other circumstances.
But how is that interpreted in practice?
In reality, the authorities, especially the police doing the verification, often look for evidence of a grave and imminent threat.
Evidence like what?
Like copies of FIRs, first information reports that you filed about specific threats or attacks against you, police reports, documentation.
Are there any guidelines on what constitutes a grave threat?
The MHA has guidelines mostly aimed at those rare PB license applications, but they give a sense of the seriousness required even for NPB threat assessment. They mention things like living in terror-prone areas, being a known target, certain high-risk officials or politicians, or their immediate families facing threats.
But proving a grave and imminent threat sounds very subjective for an ordinary person.
It absolutely can be. You need to convince both the police and the licensing authority. Objective proof like FIRs helps, but there's still judgment involved.
Any other factors?
Well, some court rulings suggest the absence of a specific documented threat shouldn't automatically disqualify someone if their overall circumstances create a reasonable fear. But the police report is hugely influential. And anecdotally, sometimes factors like perceived financial standing have reportedly played a role in decisions, though that's not explicitly in the law. It's a tricky area.
And this police verification, you said it's deep. What exactly do they check?
It's comprehensive.
Yeah.
They verify your identity, your address, criminal history, obviously. They assess your claimed threat. Is it credible? Your character, your temperament. They might talk to neighbors, ask for references.
Really?
Oh, yes. They also try to gauge if you seem capable of handling a firearm safely. They gather any other relevant info. It's a full background check.
How does that process actually work logistically?
The licensing authority sends the request to your local police station. The local police do the groundwork checks, inquiries, maybe interviews. They write a report. It goes up the police chain, maybe cross-referenced with crime databases, and finally gets sent back to the licensing authority.
How long does that take?
The rules suggest timelines like 45, 60 days for the report, but delays are pretty common. It can take a while.
Okay, so eligibility isn't one size fits all. There are specific things for different applicants too, right? Like inheriting a firearm.
Yes, Rule 25 covers legal heirs. You might get a license for an inherited gun if the original owner passes away, or if they're over 70, or held the gun for 25 plus years. The definition of legal heir is also broader now.
Do heirs still need to prove a threat?
The genuine need part might be viewed a bit more leniently, but they must still meet all the basic eligibility requirements: age, fitness, clean record, and get a positive police report. Plus, specific documents are needed: death certificate, proof of relationship, and indemnity bond.
And OCIs we mentioned mainly for heirlooms with conditions.
Right. Permanent residency, agreement to deposit if they leave, very specific.
What about sports shooters? Can they get licensed younger than 21?
Potentially, yes, but under strict conditions. They need proof of active membership in a recognized club for at least 2 years, competition certificates, maybe recommendations from the NRAI or state associations. There are specific forms for sports applicants, too.
Government employees, armed forces or police.
They usually need an NOC, no objection certificate from their department, proof of service. They might be exempt from the formal training certificate requirement. Rule 12 says their applications should be considered if there's a genuine need related to their job.
And business owners needing protection for their premises or assets.
They'll need a lot of documentation: business registration, details of the business nature, high cash handling, valuable stock, turnover figures, employee numbers, specific justification for the threat related to the business. Proof of financial status like tax returns is almost always required too.
So it really boils down to your specific situation and the justification you can provide. Assuming someone thinks they qualify, how do they actually start the application?
First step is the right form. The 2016 rules have various forms. For a new individual license to possess and carry, it's usually Form A1. Renewals often use A3, different forms for dealers, manufacturers, etc.
And the application needs to state the reason.
Absolutely. Clearly state the purpose: protection, sport, crop protection, whatever the valid reason is.
How do you submit it? Is it all online now?
It's moving that way. The NDL ALIS portal, that's the National Database of Arms Licenses System, is the main platform now for many services, including new applications and renewals.
A deal, LAS, okay.
You register online, apply there. But depending on your location and the license type, you might still need to submit physical forms or documents to the licensing authority's office, the DM or police commissioner in your area. Generally, you apply where you live.
I also saw mention of a UIN, unique identification number. What's that?
Ah, yes. Very important since 2016. The UIN is mandatory for everyone with a license, and individuals, dealers, institutions, everyone. Your licensing authority issues it.
What does it do?
It basically links all your firearm licenses and records under one unique ID. New applicants get it during the process. Existing licensees had to get one assigned. It's for better tracking and management.
A key part of the system then. Okay, got the form, know about the UIN. What about the documents? You mentioned a lot earlier. It sounds like building a case file.
It really is. You need a comprehensive dossier. Let's break it down. Core documents first.
Go ahead.
Proof of ID Aadhaar is preferred. If not, an affidavit plus alternatives like passport, voter ID. Proof of residence again, Aadhaar or passport preferred, or alternatives like recent utility bills, registered rent agreement, proof of date of birth, school leaving certificate like matriculation, passport, recent photos.
Okay, standard stuff mostly.
Then the medical fitness certificate, Form S3 from that MBBS doctor. Proof of financial status, latest income tax returns, salary slips are common.
All right, that covers the basics. What about justifying the need?
A written statement explaining why you need the license. If it's threat-based, copies of those FIRs or police complaints are crucial. If it's for property or business protection, documents proving ownership or business details.
Training certificates, storage proof.
You might need a firearm safety handling training certificate, Form S1, though implementation varies. You definitely need the written undertaking for safe storage, Form S2, promising you have a secure place like a safe or steel almirah.
Okay. Anything else applicant-specific?
Yes, depending on who you are. The NOC for government servants, sports certificates, proof of heirship, detailed business docs, character references if asked, maybe specific affidavits. It's quite a list.
It really drives home how seriously this is taken. Once you submit all that, what happens next? The official scrutiny.
First, the licensing office does an initial check. Is everything there? Application complete. Then it goes for that mandatory detailed police verification we talked about.
And that police report is key.
Hugely important. It heavily influences the final decision. After that report comes back, the final decision rests with the licensing authority, DM, police commissioner, state governed, or MHA for PB weapons.
Based on what?
Based on everything. Your application, all the documents, the police report, their overall assessment. They might also call you in for a personal interview.
What are the main reasons an application gets rejected?
Section 14 of the Act lists grounds. Applying for prohibited arms without central government, okay, obviously. Being in a prohibited category under Section 9 underage, certain convictions, that's straightforward.
Any less obvious reasons?
Yes, the authority can refuse if they just deem you unfit to hold a license for any reason. That's very broad discretion. Or if they think granting the license wouldn't be in the interest of public peace or safety.
There's a lot of judgment involved.
Significant discretionary power, yes.
It sounds like this could take a long time and be quite uncertain. What are the typical timelines and roadblocks?
Well, the rule suggests timelines maybe 60 days for police verification, then a period for the final decision. But honestly, it often takes much longer, months, easily.
Why the delays?
The discretion we mentioned, police assessment of threat, the authority's interpretation of genuine need or public safety, subjectivity plays a big role. Plus, just general bureaucratic delays can happen. It makes the outcome somewhat unpredictable.
If you get rejected, do they tell you why? Can you appeal?
They are supposed to communicate the reasons. And yes, you have the right to appeal to a designated appellate authority within 30 days.
And if the appeal fails?
Then you might have recourse through judicial review by petitioning the High Court. But overall, getting a license requires patience, meticulous preparation, and persistence. It's a complex hurdle race.
Okay, let's fast forward. Someone successfully navigates all that. They get the license. They buy the firearm. Is that it? Are they done with the legal side?
Oh, absolutely not. Getting the license is just the start. Now comes the huge responsibility of understanding when and how you can legally use that firearm, especially for self-defense.
Right, that brings in the Indian Penal Code, doesn't it? The right of private defense.
Exactly. Sections 96 to 106 of the IPC. And it's crucial to understand this isn't a license to shoot whenever you feel threatened. It's a specific legal shield, only available in very narrowly defined situations.
So what's the basic idea? When can you legally use force to protect yourself or your property?
Section 96 says nothing done in private defense is an offense. Section 97 explains what you can defend: your own body or someone else's body against any offense affecting the body, and your own property or someone else's against theft, robbery, mischief, criminal trespass, or attempts at those.
It's seen as a self-preservation right when the state can't help immediately.
That's the core idea, yes.
But there must be limits. You can't just use disproportionate force, surely.
Definitely not. Section 99 lays out key restrictions. Generally, no right of private defense against a public servant acting in good faith in their official capacity, even if their action isn't strictly legal. Unless their act gives you reasonable fear of death or grievous hurt, and you know or believe they're a public servant. Similar rule for someone acting under a public servant's direction.
What else?
Critically, no right of private defense if you have enough time to get help from the police or authorities. If you can safely call for help, you generally should.
And the force used?
Must be proportional. You cannot inflict more harm than is necessary for the purpose of defense. That's a fundamental limit.
So when does this right actually allow for using lethal force causing death? That must be a very high bar.
Extremely high. Sections 100 and 103 spell out these exceptional circumstances.
Okay, Section 100 is for defense of the body.
Yes. It extends to causing death only if the assault reasonably makes you fear death or grievous hurt yourself, or if the assault intends rape, unnatural lust, kidnapping, abduction, wrongful confinement where you can't get help, or involves an acid attack causing fear of grievous hurt. Very specific, serious threats.
And Section 103 for defending property. When can that justify lethal force?
Again, only in specific, dangerous scenarios. Robbery, housebreaking by night, arson on a dwelling or property storage, or theft, mischief, or house trespass committed in circumstances that reasonably cause fear of death or grievous hurt if you don't defend yourself.
So outside of those very grave situations listed in 100 and 103.
The right does not extend to causing death. It's limited to causing harm other than death.
How do courts interpret all this? What are the key things they look for?
They focus heavily on imminent danger. The threat has to be immediate, present, real. not something that happened yesterday or might happen next week.
What about the defender's state of mind?
Reasonable apprehension is key. Would a reasonable person in that exact situation have genuinely believed they were in that level of danger? It's about the reasonableness of the perception of threat, maybe even more than the actual danger.
And proportionality, necessity.
Absolutely crucial. Was the force used necessary and proportionate to the threat faced? Not excessive, not vengeful. Courts allow some leeway for actions taken in the heat of the moment, but gross excess isn't excused. And necessity was force the only option. Could you have safely retreated? Could you have called police? The right is defensive, not punitive.
And using a firearm specifically brings extra scrutiny.
Definitely.
Yeah.
Because a firearm implies potentially lethal force, you have to meet those high thresholds of Section 100 or 103 if death results. You need to show reasonable fear of imminent death, grievous hurt, or the other listed offenses, that using the gun was necessary, no other way out, and the force was proportionate.
It sounds legally perilous.
It is. Post-incident investigation will be intense. The burden of proof is on the person claiming self-defense to show all these elements were met. It's not straightforward.
Okay, so it's not just the act itself. The law also defines when the right starts and ends.
Yes, Sections 102 and 105. For defense of the body, Sec 102, the right starts as soon as you reasonably apprehend danger and continues as long as that apprehension lasts. It ends when the threat stops.
And for property, Sec 105.
It starts with reasonable apprehension of danger to property. How long it continues depends on the crime. Theft, until the thief escapes with the goods or help arrives or you get the property back. Robbery, as long as the threat of death, hurt, restraint continues. Trespass, mischief, as long as the act continues. Housebreaking by night, as long as the trespass continues.
There's even a bit about risking harm to an innocent bystander.
Section 106, yes. If you're facing a deadly assault and can't defend yourself without risking harm to an innocent person nearby, the law says you're justified in taking that risk.
Wow. It's an incredibly detailed framework. Getting the license is one thing, but knowing when you can legally use the firearm, that seems even more critical.
Absolutely.
Let's shift gears then. Beyond use of force, what are the ongoing responsibilities of being a lawful firearm owner? It's not just get license, get gun, forget it's right.
Yeah, not even close. Owning a firearm legally comes with significant continuous duties. Safe storage is a big one. Rules for carrying it, keeping your license current, and understanding the penalties for messing up.
Okay, let's start with safe storage. The 2016 rules really emphasize this.
They did. Rule 10 is key. When you apply, you have to give a written undertaking form S2
Undertaking what?
that you have or will get secure storage, like a proper safe or a steel almirah, to keep the firearm and ammo locked up securely,
Why the emphasis?
to minimize theft risk, and crucially prevent unauthorized access, especially by children. The undertaking also includes committing to safe practices like storing it unloaded, maybe dismantled, and educating kids about the dangers.
Can the authorities check your storage?
They have the power to inspect, yes, especially for dealers or manufacturers, but potentially for individuals too. Even curios or antiques need secure storage. It's a formal, documented duty now.
Makes sense. Safety first. Now, what about carrying the firearm in public? What are the rules?
You can carry it if licensed, but under strict conditions. It must be in a proper holder, completely covered, no open display generally, and you must keep control of it.
What can't you do?
Brandishing it is a definite no-no. Discharging it in public, even blanks, or in firearm-free zones, that can mean instant license revocation, seizure, penalties.
What about celebratory gunfire, like at weddings?
That's a specific offense now under Section 25(9) if it endangers life. Big trouble.
What if police ask to see your license?
You must produce it immediately. Refusal can lead to them demanding your name, address, possible arrest if you refuse that, give false info, or seem like you'll abscond.
Even just acting suspicious while carrying legally can cause issues?
Yes, carrying even licensed arms suspiciously can lead to arrest.
What about where you can carry it? Is the license valid everywhere?
Usually not. Your license typically specifies an area, your district, maybe your state. To carry it beyond that, you need an area validity extension.
And you get that.
Apply with justification. Business travel, property elsewhere, service needs, documented threats in another area. Use Form B2.
What about an all-India validity AIV license?
Anywhere, granted sparingly by state govs or MHA, usually for MPs, all India service officers, defense personnel. based on proven need, often for a limited time like 3 years, subject to review.
Are there places you can never carry?
Yes, carrying is prohibited in notified disturbed areas, and temporary restrictions can apply during elections or under prohibitory orders like Section 144 CRPC.
So constant awareness is needed. Okay, maintaining the license itself. It expires, right?
Yes, typically valid for 5 years now since the 2019 changes. It's your responsibility to renew it on time.
How far in advance?
Rule 24 says apply at least 60 days before expiry, using Form A3 usually. Renewal might involve inspecting the weapon again, maybe re-verification, especially every other renewal, or if there are concerns.
What if you forget to renew?
Then your possession becomes unlawful. Big problem. You also need to keep your UIN current.
What about moving house?
If you change address permanently, or even temporarily for over 6 months, you must inform your original licensing authority. If the new place is under a different authority, you notify them too, and might need to register the license there. Form B1.
What if the license gets lost or damaged?
Apply for a duplicate. You'll usually need an FIR or police report, NCR, if it's lost.
Selling or transferring the gun?
Requires prior permission. Form B2. Section 5.2 also says you must inform the DM or local police in writing before you sell transfer, giving buyer details. Then there's a 45-day waiting period, and the buyer must be legally allowed to have it.
What about buying another gun once you have a license?
Often needs a specific endorsement on your license, Form B2. There might be a time limit to buy it. Once bought, you usually have to show it to the authority for inspection and entry on the license.
It sounds like a lot of ongoing paperwork and procedures just to stay compliant.
It is. It requires diligence.
And if you slip up,
Yes.
fail to follow these rules, what are the penalties?
They can be severe. Chapter 5 of the Arms Act, Sections 25 onwards, details them. We're talking potential mandatory minimum jail time, up to life imprisonment for serious offenses, plus hefty fines.
So things like?
Unlicensed possession carrying, Sec 3, having more guns than allowed, Sec 3.2. Unlicensed manufacture sale, Sec 5. Dealing in prohibited arms without authorization, Sec 7. Unmarked firearms, Sec 8. Prohibited persons having guns, Sec 9, not depositing guns when required, Sec 21, carrying arms in disturbed areas, Sec 24AB, using arms illegally, Sec 27, selling to unauthorized people, Sec 29, breaking license conditions or rules, Sec 30, negligent use or that dangerous celebratory gunfire, Sec 25(9). The list is long.
And using the gun during another crime.
Can increase penalties under the IPC, and as we said, unjustified self-defense use can lead to homicide or murder charges.
Can they take your license away?
Yes, Section 17 allows suspension or revocation if you become prohibited, break conditions, gave false info, or if it's deemed necessary for public safety. Plus, illegal firearms ammo can be seized and forfeited.
It really drives home the sheer weight of responsibility involved. It's absolutely not something to enter into lightly.
Not at all. I think this deep dive makes that crystal clear. Firearm ownership in India. It's a strictly controlled privilege. You need to meet tough eligibility criteria, navigate a maze of an application process, accept limits on what you can own, have very narrow justification for use, and shoulder significant ongoing duties.
So for anyone listening, maybe considering applying or already a licensee, what are the absolute must-do recommendations from all this?
First, understand the law thoroughly. Arms Act, Arms Rules, IPC on self-defense, read them, understand them.
Honesty in application.
Crucial. Be completely honest, accurate, provide everything required, prepare for intense scrutiny, and be ready to solidly back up your stated need.
Safety.
Paramount. Get proper training in handling and safety. Follow the secure storage rules religiously for the gun and the ammo.
Understanding use of force.
Deeply understand when you are legally justified to use force, especially lethal force. Know those IPC sections inside out. Compliance with every rule, every license condition is non-negotiable.
And if unsure,
get legal advice. Don't guess. Finally, embrace the seriousness of it. Owning a firearm legally is a profound responsibility.
it's definitely demanding, complex. The path is intricate, loaded with duties, all within a framework designed for public safety. Hopefully, this deep dive gave you a solid map of that territory, but the ultimate onus is on you, the listener, to dig deeper into the legal specifics and approach this privilege with absolute diligence and respect for the law. What further questions does this raise for you, thinking about this landscape of regulation and responsibility?